Hi, I'm Dan Krause. I'm an estate planning, elder law, and probate attorney. And today I want to talk a little bit about the need in a probate to notify people that you probably don't want to be notified. But first, I want to just invite you to subscribe to our newsletter. Just give us an email at newsletter@friendly.law, and we will get you on the list of some great newsletters, some good information. So I want to tell you a little bit of a story about a case that I've been involved in. It was a person who moved here from a foreign country and became a citizen somewhere in Europe. And they lived here for decades. And they made friends and they had acquaintances, and they decided that upon their death, they wanted things to go to their friends here in the United States because they hadn't had any contact with their family back home for quite some time. So they did a will. They created a will. The will gives all of the assets to people and charities that they were familiar with here in the United States. Here's the problem. Now, when you have a will, and the will is going to control the distribution of your assets, the will must go through the probate court. The probate court is the court that supervises the distribution of assets for people that don't have trusts. So the probate court has a lot of rules and regulations. One of which is you have to notify all of the family members that would inherit in case the will was no good. So there's rules about intestate succession and who gets your stuff if you have no will. And Wisconsin probate court, and probably every probate court in the nation, requires that you find those people that would inherit from you if you didn't have a will, and notify them that they have the ability to contest the will to see if they can get anything. This can cause some problems that the person probably would not want. One of the problems that it causes is extra expense. Now the estate, in the case of the woman who lived in Europe, moved from there several decades ago, there has to be a GAL appointed in the probate. A GAL is a guardian ad litem, and the guardian ad litem tells the court whether the unknown interested parties are going to want to have a contest against the will, if they're going to want to challenge the will or challenge the personal representative that was appointed under the will. Because after paying somebody to do research, they couldn't find all of the potential heirs that may be in Europe, or they may be anywhere around the world, in fact. So now we've got the extra expense of paying somebody to research the heirs. We've got the extra expense of hiring a GAL, which is required by the court, which is an attorney that writes a report to say whether or not the unknown heirs would have an objection to the will. And this, of course, all causes delays. It causes the people that you want to get stuff to get less stuff because of the expense, etc. Another case that I've talked to a client recently about is they wanted certain things to go to their family members. They didn't have any children, they weren't married, and they wanted things to go to their sister. But the thing is, they also had a brother and another sister that they did not want involved at all. They didn't even want those people to know that they, after they died, whether they had died or not. This person is not dead yet, but they didn't want these people involved at all in anything that they were doing during life or after death. Well, the problem with that is if we do a will for that person, then after that person dies, the will is brought into probate court, and then the probate court requires that you notify the brother and the sister that aren't going to be getting anything. It might make them angry. It might invite them just to contest the will and see where they can get with that. The prospect of having to notify a brother and sister after she had died made this client decide to go with a trust-based plan where there's no requirement that you notify anyone who's not going to get anything. So just a short little blurb for please plan with a trust, especially in the case where you don't want certain people to know or to have the opportunity to object if you should pass away. If you have questions about this or any other estate planning, probate, or elder law related questions, please give us a call. The number is 608-268-5751. Thanks for spending time with me today.